Okay, good afternoon, everyone, and welcome. We're really happy to have our viewers and to be able to convene this panel on key questions in U.S. foreign relations law under the Biden administration. I want to begin by just providing a little bit of context so that viewers can have a sense for what it is that we're trying to achieve with this panel. In short, the context is really one of significant challenge and also instability in a variety of ways that are relevant to the field of U.S. foreign relations law. Domestically, we have the problem of hyperpartisanship. We have an associated problem or apparent problem with a separation of parties rather than of powers. And we have significant flip-flops in US foreign policy across recent presidential administrations. These issues have given rise to questions about the credibility of US commitments to foreign governments, and also, I think, to questions about the ability of domestic law to effectively regulate the separation of powers between the political branches. Internationally, the problems are no less significant. We have an acute need for greater cooperation on issues such as the pandemic and climate change. We have a seeming shift in the structure of international relations with a continuing increase in the power of China, an apparent decrease in the relative power of the United States, a movement toward greater multipolarity. And all of this is happening, meanwhile, as the United States moves from one presidential administration into a new one. So I think this creates an opportunity to ask important questions about the field and how it's going to evolve over the course of the next few years. In particular, what is the impact of the Biden administration going to be on the field of US foreign relations law? How might these various challenges impact the field? How might hyperpartisanship, for example, over the next 4 years influence the development of US foreign relations law? And to what extent does the field contain solutions to some of the problems that we face? To help us answer these questions, we have a panel of real experts in the field of foreign relations law, 2 officials from the US government, and then 3 leading commentators from American legal academia. From government, we have Mr. Richard Visek, who is the acting legal advisor at the State Department. We have Mr. Mark Iozzi, who is the Deputy Chief Counsel of the House Foreign Affairs Committee. And then from American legal academia, we have 3 professors, Professor Gene Galbraith from the University of Pennsylvania, Professor Shiman Keitner from the University of California, Hastings, and Professor Julian Koo from Hofstra University. So the plan is to begin with a couple of questions for our government officials, and then to turn things over to our academic commentators to have them not only respond to any comments that the US officials might make, but also identify and opine on what they perceive to be a key question in US foreign relations law for the next few years. So we'll start with Mr. Visek. We're 2 months into the Biden administration now. We've had quite a few significant shifts from what we saw under the Trump administration on issues like the Paris Agreement, US military support for Saudi Arabia, etc. But I'm wondering, is there nevertheless any sense in which the public reporting on these issues has failed to fully capture what's going on with respect to important areas of US foreign relations law? Or to put it in another way, is there anything that the US public should know that perhaps we don't fully appreciate given what's happened so far?
Well, thanks, Ryan. And before I start, I also want to thank the American Society for International Law for inviting me to participate on this panel. And it's always a privilege to see my old colleague from the Office of the Legal Advisor, or L as we call it, Shiman Keitner, who was our Counselor for International Law. And I just want to say that, every year we look forward to the ASIL annual meeting, those of us in L, but the importance of ASIL to L goes well beyond this terrific annual event. I learned long ago how important it is for lawyers and government to have groups like ASIL actively supporting and advocating for the rule of law, in our case, for the important role that international law plays. Now, to go to your point about the changes that we've seen, and obviously I can't get into a lot of internal deliberations, but I can say that it has been dramatic in terms of the changes. I think, as I said during our recent 11th annual Live from L presentation, for career government attorneys such as myself, the difference between one administration to the next, with certain exceptions, can be a matter of moving one standard deviation to the left or to the right. Sometimes, though, as I think we would all acknowledge, was the case between the Obama and the Trump administrations, and is now between the Trump and Biden administrations, the difference in policy can be much more pronounced. If you're a career public servant, you need to be able to, and I apologize for this, in the words of REO Speedwagon, roll with the changes, and be able to provide advice rooted firmly in the law with respect to very different policies. At the same time, some changes are less pronounced, and in some areas the policy is not dramatically or at all that different. And I think that's sometimes a surprise to both those outside and those within the government. In the first 7 weeks of the Biden administration, we have seen a number of changes in course, as well as changes in approach or emphasis. Recognizing that this taping precedes the annual meeting by a couple weeks, it's possible, if not probable, that there will be more such changes. However, I'm going to put my crystal ball away for the purposes of this discussion and just focus on what's happened. In terms of approach, what is clear is that one of the early themes in the Biden administration is a marked and decided emphasis on multilateral engagement and cooperation in addressing shared problems. And we're seeing that play out in a number of policy changes. Relatedly, there's what Secretary Blinken recently described as the enduring principle that U.S. leadership and engagement matter if there are to be real advances. Now, if I can, I'll highlight some of the course changes that have generated a lot of work for the Office of the Legal Advisor. You've mentioned one, signaling that the United States will be tackling the problem of climate change through multilateral engagement and cooperation. President Biden, on his very first day in office, signed an instrument bringing the United States back into the Paris Climate Agreement. And as of February 19th, in accordance with the agreement, the United States is once again a party to the agreement that we were instrumental in achieving just over 5 years ago. So I've seen us join the Paris Agreement, leave the Paris Agreement, and get back into the Paris Agreement in those 5 years. The president also issued Executive Order 14008, stating that it will be a U.S. priority to press for enhanced climate ambition and integration of climate considerations across a wide range of international fora, including the G7, the G20, and others that address clean energy, aviation, shipping, the Arctic, et cetera. Importantly for us, the executive order also directed the Department of State to prepare documents needed to seek Senate advice and consent to U.S. ratification of the Kigali Amendment to the Montreal Protocol, which is intended to phase down the consumption and production of hydrofluorocarbons, which have a high global warming potential. And then later in spring, on April 22, Earth Day, President Biden will be hosting a summit on climate change. So those are all things that, to be frank, would not have happened in the last administration. Similarly, in the area of health cooperation or international cooperation with respect to health challenges, the United States retracted its notice of intent to withdraw from the WHO, the World Health Organization. We've ceased the drawdown of seconded staff. We've resumed regular engagement. And in fact, we had one attorney who was, to show how the life of a career attorney has to be one of agility in times of transition. She began the week with Trump appointees in her delegation in one set of instructions. And then on January 20th, she got a whole new team of Biden appointees and a whole new set of instructions. And she provided excellent service to both sets over the course of the week. So that was rather interesting. The president has also issued a national security memorandum, number 1, which maps extensive lines of effort the administration is pursuing to strengthen the international COVID-19 response and to advance global health security and biological preparedness. And so that's going to be an area of work that is really going to keep us busy and has in helping to shape the multilateral engagement strategy to develop stronger global institutions, if you will. In the human rights area, I think one thing the Biden administration has made clear is that we are really going to support democracy and a commitment to human rights. And I think there's a determination that it's better to be inside than outside the tent when it comes to influencing other states. And this goes to the international engagement. Secretary Blinken announced that the United States would re-engage immediately and robustly with the UN Human Rights Council as an observer state. Also announced that the United States would be running for election to the UN Human Rights Council for the 2022-2024 term. And in a further step, we nominated Fordham University law professor Gay McDougall for election to the Committee on the Elimination of All Forms of Racial Discrimination. So, those are three, again, changes. You also mentioned the ending the support for the Saudi-led coalition's offensive operations in the conflict in Yemen. I could probably add to those a few more: rescinding the Protecting Life and Global Health Assistance Policy, which was an expanded version of the Mexico City policy. Of course, that's not surprising from one administration to the other at different parties. But also taking steps to restore funding to the UN Population Fund. Sometimes the challenges are not newly arising challenges, but perhaps ones that have faced, if not vexed, successive administrations. And I think how the Biden administration goes about it will likely involve differences in approach and emphasis, as well as perhaps the use of available tools. Some may be, more important than others. I think as Secretary Blinken noted in his speech earlier this week, we obviously have the continuing serious challenges involving Russia, Iran, and North Korea. But I think, and this is probably where common ground is found, I think both Secretary Blinken and Secretary Pompeo saw China as an especially formidable challenge, given its economic, diplomatic, military, and technological power. And again, here, there's a stated commitment, as reflected in the recently released Interim National Security Strategic Guidance, to working with allies and partners and in international organizations to engage with China. For L, that's going to translate into us being extraordinarily busy with respect to all things China, something that we have been over the past year. And I expect in the legal diplomacy area, we will continue to conduct legal diplomacy to counter China's unduly expansive and assertive maritime claims in the South China Sea. There are other policies that, I indicated sometimes people are surprised to find that some policies continue. I don't know why that's a surprise, but it does, because I think perhaps people tend to focus on particular items and miss a lot of the everyday bit of government. But one area was a policy that sort of began under the Trump administration and is going to be continuing, is with respect to space exploration, which traditionally has been a nonpartisan issue in the United States. As we've seen in the past weeks, the United States and other international partners have entered a new era of space exploration. There was the Perseverance rover landing on the surface of Mars. Human missions are planned to the moon. And future space missions will be more complex and more international than we've ever seen, and they'll take place alongside other space programs, including those of our partners and those of our strategic competitors. And so in order to develop a shared set of tools to govern these activities, last year, the State Department and NASA worked with our partners to develop the Artemis Accords, a non-binding declaration that sets out an agreed set of rules and principles building on the 1967 Outer Space Treaty. It will guide civil space activities of all the signatories. In addition to the United States, we've got Australia, Canada, Italy, Japan, the UAE, the United Kingdom, and Ukraine, all on board. And then, if I could sound like an old man for a moment, which sadly I think I have a right to, over my time at the State Department, I'm always amazed that administrations are often remembered not for how they've dealt with the challenges they've inherited or the ones that they expect to be addressing when they come in, but how they've handled new challenges. I'm reminded in 2014, none of this, was sort of planned for, but Secretary Kerry's team had to respond to, in 1 year, Russia's occupation of Crimea, the West Africa Ebola crisis, and the ISIS offensive in Western Iraq. All significant events which did not really, were not on the radar screen in 2013. And obviously already the Biden administration has had to deal with the evolving situation in Burma. The department quickly went out and determined that a military coup d'etat had occurred. In terms of L, obviously, we will continue to provide legal advice and work on all the priorities and the initiatives, as well as the everyday, stuff of government, if you will. I mean, we are a general counsel shop, and we handle everything from domestic to international law. But in the legal diplomacy space, I think one of the things we've been busy, but I think we're going to be busier. For example, when the annual meeting takes place, a number of us will be engaging in our twice yearly legal dialogue with the EU and its member states. We've already met with them informally. And a day later, we're going to be meeting with the member and observer state legal advisors of the Council of Europe, and we'll be doing that for 2 days. So there has not been a respite for L. We were busy in the last administration, and I think we're very busy in this one. But I think everybody is, good public servants that they are. Everybody's very energized. And so with that hopefully not too long summary, I'm delighted to turn to my colleagues on the panel for their perspectives and frankly, their advice.
Great, thank you so much. We'll now ask a similar question of Mr. Iozzi. You're working with the House Foreign Affairs Committee. I'm wondering, to what extent have the priorities and efforts, the work of the committee changed since the advent of the Biden administration and the return of Democratic control of both houses of Congress?
Yeah, absolutely. First, thank you for having me. I think this is shaping up to be a really great panel. I should just note from the top that I represent the House Foreign Affairs Committee and the majority staff, but I'm speaking in my own capacity off the record today. But to jump right into your question, I think Congress is coming out of 4 years of trying to wrestle with a lot of changes to what had been longstanding bipartisan and sort of fundamentals of U.S. engagement in the world. And we're coming out of 4 years of wrestling with that and trying to figure out how to use the current moment to sort of reassert American leadership in the world in the way that we had seen it be effective in the past, and in the ways that comport with sort of values of at least the majority in Congress. I think we often talk about how the Foreign Affairs Committee is the most bipartisan committee in Congress, and we move a lot of legislation that's all bipartisan. But I think that has really been strained through a range of sort of decisions, not just impeachment, but also sort of a reevaluation by many in American politics of sort of our NATO relationship or longstanding arms control agreements, or sort of these sort of fundamentals that hadn't really been as controversial in the past. So we're trying to figure out what that means for Congress and sort of bipartisan relationships going forward in sort of this mix of a political and policy environment that we work in. Despite all of those challenges, we have a new chairman in the committee this year, Gregory Meeks from New York, and this is the third incoming chairman that I've worked with, from Senator Menendez when he first came over in the Senate, and Congressman Ingle when he took over the committee. I think each chairman brings new priorities and new opportunities with them, and Chairman Meeks has really set out to push the committee forward on leading on some of these issues that are priorities for our members and sort of reasserting U.S. leadership in the world, without, I think, trying to take a back seat and wait as the administration figures out sort of its the whole range of issues that are on the plate for it. So we had our first markup in our committee, and despite these challenges in remaining bipartisan, it was a very bipartisan markup, and we moved State Department authorization legislation that, as folks who follow this may know, the State Department hasn't been authorized in, by my count, 19 years. So some of those legal authorities are getting very old, and that starts to be a very big problem. And it also, when we authorize the Department of Defense regularly, annually, has led to a situation where when there's a new problem in the world, it's easy to pass an authority for the Department of Defense to deal with that problem, and much harder to pass a new authority for the State Department to deal with that problem. So that's something that was very important to the chairman. It's very much a nuts and bolts management bill, but the goal is to sort of reassert muscle memory in Congress that authorizing the State Department is something that's important. Another piece of, I think, very significant legislation in the same vein is the Cyber Diplomacy Act that intends to establish a cyber bureau at the State Department. And I won't get into the ins and outs of sort of cyber policy, because I think we'll probably cover those later in the panel. There's a lot to do in the diplomatic space that affects that's in the realm of cyber policy. And Congress has really been trying to push forward to set up the State Department to deal with the security, economic, and human rights aspects of engagement in cyberspace. So that's some of the sort of the affirmative things that we're putting on the table. But to deal, sort of get back to your initial question of how we're approaching this new administration, I think the last 4 years taught Congress where some of the real weaknesses are in the relationship between the legislative branch of government and the executive branch of government, and where that balance of power might not be in the place where a lot of members of Congress want it to be. I think key places where we've seen that come up is in arms export controls and in sanctions, places where Congress has delegated huge swaths of Article 1 authority for a long time under mechanisms of control. However, Congress's control, I don't think, has mechanisms, for example, concurrent resolutions of disapproval, haven't really reckoned with a post-INS v. Chadha legal landscape. And so Congress has really struggled to figure out how to control these delegations of Article 1 authority that it has provided to the executive. And I think this has been such a long-standing problem that some of these issues are even described back to Congress in briefings as, when Congress seeks to exert control, as Congress infringing on the president's inherent Article 2 authorities to, for example, control arms sales. I think that, and really, I think it's just been so long since anyone just stepped back and thought that these are delegated Article 1, enumerated Article 1 authorities. So Congress is trying to figure out how to effectively assert control in a way that still recognizes that the president is the one who is charged under the Constitution with conducting foreign policy, but also best positioned to make a lot of these foreign policy decisions in real time. So that's a challenge that there are a number of proposals on the table. And I think those proposals are being spurred forward by member interests in things like sanctions in response to the killing of Jamal Khashoggi, and also sort of lingering concerns about how President Trump used sanctions authorities, for example, to sanction the ICC, that was sort of out of step with what many in Congress thought should be done. The other space that I'll cover quickly, maybe we can get to more in conversations, is in places where congressional inaction has just ceded authority to the president. I think one of the big places that's happened is in more powers. The president obviously has, Article 2 authorities to defend America and use military force. However, Congress laid out in 1973 a framework that put sort of a very strong congressional foot forward. However, there are serious gaps in the War Powers Resolution, not just in its enforcement mechanism from Congress's perspective, but also in how it's been interpreted over time, and Congress's lack of response to executive branch interpretations that, for example, narrowed the definition of hostilities so that you can fit a whole war into the space outside of having to notify introduction into hostilities to Congress. Or things like Section 3 of the War Powers Resolution that requires the president to consult with Congress prior to an introduction into hostilities in every possible instance. And it's been a really long time since there's been a real consultation about an introduction into hostilities. And I think that's what happens when Congress doesn't sort of fill the space. So Congress is looking not just to repeal or update existing authorizations, but also to deal with sort of that fundamental power balance on who is in charge really of controlling uses of military force. I think I'll leave it there for now.
Okay, great, thank you. So let's turn over to our professor panelists now. I'll begin with Professor Galbraith. Any reactions to the comments by Mr. Visek and Mr. Iozzi? And in addition, what are your thoughts on key questions in foreign relations law under the Biden administration?
So let me begin by echoing the thanks to you, Professor Scoville, and to the American Society of International Law, and to the International Law and Domestic Courts Interest Group, which is setting forth this extent. I'm just so excited to be here on the panel. So we're, of course, very early in the Biden administration. And I guess I'll say what hasn't been said here yet is that at my highest level of generality, my overall reaction is just one of thankfulness and relief. So some long past British diplomat defined diplomacy as, quote, the application of intelligence and tact to the conduct of official relations between governments of independent states. I was very happy to hear President Biden give his recent speech in which he said diplomacy is back at the center of our foreign policy. and that America will engage with the world once again. I think Mr. Visek's comments really highlighted just how much power rests with the president and with administrations as a matter of law to tailor U.S. policy and to radically tack U.S. policy back and forth. And he talked about some of the acts that were both easy and as a matter of law and as a matter of policy for the Biden administration to accomplish right off the bat coming in, including with respect to the Paris Agreement and the World Health Organization. And I would add things like the rescindment of the travel ban that had been not so subtly aimed at mostly Muslim majority poor countries. We're going to be seeing in the next few months to years some of these questions about issues that will be easy for the Biden administration as a matter of law, having those either independent presidential powers, potentially exclusive presidential powers, or as Mr. Iozzi said, the delegated presidential powers to do as a matter of law, but that it may be challenging as a matter of policy or of international negotiation. And we'll see that, for example, with whether we bring back the Joint Comprehensive Plan of action with Iran. And I'll be very interested to see what comes out of Congress in terms of framework legislation aimed at rolling back delegated powers by the president or adding on procedural requirements to them, or trying to channel and shape some of the dialogue about what powers lie exclusively with the president versus what are ones that are subject to congressional delegation. I'm not sure I would say that the conduct of U.S. foreign policy or the sort of choice of U.S. foreign policy is entirely a matter of presidential control. One thing that I've been interested to find out in my own research is that at the time of the framing, there really was a distinction between policy and negotiation. And we use the word diplomacy now to cover both of those things. Diplomacy wasn't actually a word that existed at the time of the framing. And yet somehow this idea of an exclusive presidential power over diplomacy has arisen to cover all of this power, where I think it could be more appropriately channeled. Now, Professor Scoville asked us to identify each one issue that we'll be watching closely as a matter of U.S. foreign relations law. And let me pick one where I is in some ways about expanding presidential power as a constitutional matter, and in some ways about constraining it. And that's the issue of whether President Biden has the ability to rejoin the United States to treaties that the United States entered into long ago with the advice and consent of 2/3 of the Senate, but from which President Trump unilaterally withdrew the United States. And the Open Skies Treaty, which is a multilateral post-Cold War treaty that allows for military overflight for purposes of arms control monitoring, is the most prominent example. Now, I've argued that if one president can unilaterally withdraw the United States from a treaty to which the Senate advised and consented, then another president should typically be able to rely on that same original resolution of advice and consent in rejoining the United States to the treaty. And this issue is unsettled as a matter of domestic law, largely, I think, because it really hasn't come up. Past presidents have been cautious and not withdrawn the United States unilaterally from too many important treaties, especially multilateral ones. And I think that this rejoining power is important as a structural matter. For if presidents can unilaterally withdraw the United States from treaties, but not unilaterally rejoin them, then this weakens the force of the Senate's original resolutions of advice and consent, which are laboriously achieved and represent supermajorities. If there's no rejoining power, then one president can cancel out all of this laborious work by treaty withdrawal. Whereas with the rejoining power, by contrast, the Senate resolution of advice and consent operates in a manner akin to a delegation of power that future presidents can draw upon. And I think this is important actually for the preservation of the treaty power. If the Biden administration succeeds in what Mr. Visek mentioned and somehow persuades 2/3 of the Senate to approve the Kigali Amendment, the Kigali Protocol to the Montreal Protocol, then, and we know that, as we've seen in recent times, 2/3 of the Senate is very challenging to get on anything that is even remotely controversial, and certainly on things that are have become issues of partisanship where perhaps they they should not. And so if it takes all the work to get 2/3 of the Senate, and then the next president can just go ahead and withdraw the United States and a future president cannot withjoin, then I think the incentives for presidents that want to engage in international agreements are going to be even more than they were during the Obama administration, to try to come up with ways to do things as was done in the Paris Agreement, where you don't go to Congress or the Senate at all. So that's one thing that I'll be watching with interest. I would like to see rejoining along the lines that I've laid out, as I think this would be a valuable precedent to set now, as a hedge against future presidents who are trigger happy about treaty withdrawals. So with that, I'll pause and be interested to hear what Professor Keitner and Professor Koo have to say.
Yeah, so I guess maybe we should proceed to Shuman and Julian first, and then with the time left over, we'll have questions for each of you. So Shuman, Professor Keitner, please.
No, first name is great, and it's just delightful to be here. And without sort of spending too much time on prefatory thanks, because I see the clock ticking. Nonetheless, thank you to the International Law and Domestic Courts Interest Group, and to Mark and Rich especially for taking time out of your busy days. It was indeed the privilege of a lifetime to work in L. And what Rich didn't emphasize perhaps is not only did the legal team continue working through some very major policy shifts between administrations, but is also for the past year been doing so during a pandemic. So that is really laudable, and something for which we are all so very grateful from our civil servants. So the bipartisanship that Ryan mentioned, I think, is really worth noting here. I think Mark also said, certain things that had traditionally been bipartisan have now become more fractured. And I noticed, interestingly, in that interim national security document that was mentioned earlier, a real focus, and perhaps a new focus, on the importance of communicating to domestic audiences the value of our international engagements. And so I really was glad to see that, and really hope that that's something that, obviously Rich, by virtue of his participation in this panel, and then all of us who are members of the American Society of International Law, whose mission also is to, broader educate and inform about the value of our international engagements. I also do think there have been points of continuity. So Mark mentioned the ICC, that it has been a consistent position among administrations that the ICC should not exercise jurisdiction over the nationals of non-states parties. However, as Mark mentioned, the approach that different administrations have taken to conveying that position have been very different. And indeed, the sanctions that we've imposed, not only vis-a-vis the ICC, but in a range of situations, I was glad to see are under review. And I think we really do need to recalibrate our use of sanctions, which is something that Congress certainly has, I'm sure, some views on and will want to maybe play a more active role in. There's also a role for courts, right? And so just with the ICC example, as many of you know, those sanctions are also being challenged in court to the extent that they affect, for example, our fellow law professors who are and have been giving support and advice to the work of the ICC, and whose First Amendment rights are implicated by these sanctions. And so the courts also may have a role to play. The area that I'll be watching, among many others, is the area of cyber policy that Mark mentioned. And so maybe I'll just take a couple minutes to put a few things on the table, understanding that we'll have to use that Zoom conversation feature at the annual meeting that follows this recorded panel to dive in more detail and engage with members of the audience on all of these issues that we've raised. But I thought it was very interesting that Mark noted that the Defense Department's authorizations on a range of issues have tended to come more readily than State Department authorization. And that may be one of the many reasons that we see DoD taking ownership of many decisions in the cyber policy area that we might traditionally have thought would have belonged, or at least have had a significant role, both for the State Department in terms of our engagement internationally, and then from DHS in terms of our domestic critical infrastructure and steps to protect domestic infrastructure. And so I'll be interested to see what the overarching re-emphasis on diplomacy brings and how that cashes out specifically in the cyber area. As many on this call know, in 2018, DoD produced a cyber strategy document articulating a new policy of defending forward. There are different views about how much of a shift in actual practice that signaled versus a shift in tone and vocabulary. But nonetheless, I think that is a significant shift, and it will be, I think, surprising if we saw the the Biden administration walk that back to any significant degree, at least on paper. But in practice, and this may be something that those of us on the outside that will be less visible to us, but those of you in Congress and on committees hopefully will be able to get more visibility into, if in practice we see more coordination among different departments and more consideration of some of the diplomatic consequences potentially of this strategy that we have announced. I think who is at the table in making these kinds of decisions is critical. And as Mark pointed out, Congress delineates the authorizations, Congress provides the funding. And in 2019, in the NDAA, Congress started saying, we want more, at least reporting of what's going on here, of who's making decisions, of what decisions are being made. And so it will be interesting, again, to see whether those reporting requirements are complied with, and then to the extent they are, if they're really successful in getting Congress back into the conversation about how it wants its authorities to be used. Congress also has a role in delineating what the courts can do in this space. So switching gears from the use of our cyber capabilities to some of the other tools in our cyber toolkit, the Department of Justice under both the Obama and Trump administrations has been indicting both cyber criminals, but also actors who have been acting on behalf of nation states, right? And the indictments, very detailed indictments that have been put into the public domain, describe those nation state connections in often painstaking detail. The current position of the executive branch is certainly that individuals can be prosecuted, even if they have nation state connections, and moreover, that entities can be prosecuted, even if they have nation state connections. And even outside of the cyber context, there are some pending prosecutions against state-owned corporations. One issue that has come up with respect to the entities is whether there's actually a legal basis for criminal jurisdiction over state-owned entities at all. And that's something that I've been working on recently, and that I think Congress can usefully step in to clarify. But I also think that thinking through the role of prosecutions in trying to deter, punish bad behavior in cyberspace, however we define that, is something that we're going to need to coordinate and articulate. And then finally, with respect to cyberspace, the other question would be if there's a role for criminal prosecution, is there also a role for civil actions? And as Mark knows, my colleague, formerly of Third Way, now of the State Department, Allison Peters, and I wrote a piece in Lawfare some months ago arguing strenuously that the answer to bad behavior by nation states in cyberspace is not to let folks go around suing them. And so I think we've got a lot of role for Congress here, both in creating statutory causes of action and criminalizing conduct, and then also in delineating, particularly with respect to nation states themselves and state-owned entities, what immunities may attach to that conduct, which of course will also then play a role in the United States' position vis-a-vis what we think customary international law requires in that area. And I'll stop there.
Great, thank you, Professor Kreitner. So moving to Professor Koo, same question for you. Any reactions to the comments from Mr. Iozzi and Mr. Isek? And what would you identify as a key question under the Biden administration.
Thanks. Yeah, and it's tough to go last with this group, so I'm honored to be on this panel, and also just so glad to be able to talk. I forgot how much I enjoyed ASIL conferences until I couldn't go to them anymore, and how much. So I really do appreciate even this little bit of it, and thanks so much for including me as well. Just a quick thought. I always have such great respect for those, for Mark and Richard, who've been working in government, but I have greater respect because of the dramatic shifts we've seen in the last two administrations, or I don't know how you put it, 5 years. And it must have been a remarkable time, I think. I think what I learned was that my academic sensibility, which is that individuals don't matter as much as institutions, has been tested dramatically, right? That individuals can make a huge difference, but institutions are pretty sticky, right? Institutions stabilize things, and the law is a big part of that. So the president might say, well, let's just do this. And then, no, we have a procedure, we have a law, you can't do that. So that's what I really learned. And I feel like that's something what I've taken away from what we've learned the last 5 years, is that institutions are not perfect. They don't solve everything, but they are relatively strong, and they do impose a lot of stability, and provide a lot of needed continuity. And I appreciate all the work you guys have done, all of your colleagues, but also just I'm thankful that America survived. So that's also a good thing. But in no small part because of the work of people, but also I think because our institutions mattered. But my sort of simple-minded view, or not totally simple-minded, but that institutions were totally dominant and we're just kind of creatures of them, has been tested a lot, and that's sort of learned. Now, just a quick thing. I have a couple things I want to say that I think might bear on what I think Richard and Mark were also mentioning, also Shemin and Jean, which was that, I think I want to place my bet on something that's not a specific legal issue, but that a foreign policy issue that I think is going to drive the law. And I think, with all due respect to all the other numerous zillion problems we have in the world, my bet is that China will arise as the dominant foreign policy focus for the next administration and maybe for the next decade. And that it will also dominate our foreign policy discourse in a way that will shape our foreign relations law. In the way that the war on terrorism really focused us on questions that we knew about, but we didn't really focus on. We never really explored the scope of the president's article of power to detain people or interrogate people or to conduct drone strikes until they started doing them pursuant to a very unusual global war on terrorism that we also never thought of before. In the same way, perhaps, that the post-Cold War period focused our interest in international institutions and multilateralism in a way that we probably didn't think about them before. I'm old enough now to see what I think predict a third shift, which I think competition with China is likely to be the dominant foreign policy focus among policymakers, and that will drive almost everything, and we'll see law sort of react to that as well. So let me just give quickly a couple examples of why I think that might matter in the law. So where I see the most obvious arena for competition with China, for instance, is economic competition. The most legal manifestation of that are the president's exercise of his economic sanctions powers or his economic powers. The statute I'm thinking most of is the IEPA, International Emergency Economic Powers Act, which can pretty much do anything. Pretty much, if you really goes down to it, if I had to tell a student, the answer is, can you do it under IEPA? The answer is, yeah, pretty much, at least against a foreign national. And the interesting question is that, of course, IEPA requires the president to declare an unusual national emergency effectively in order to invoke those powers. And the courts have been very deferential, and there's no one's ever seriously called into those questions. But to the extent that continues to be used, and the President Trump experimented with them, but not controversially, by targeting communications technologies and so the supply chain for communication technologies, I don't think this is something that will be a dramatic shift. But using IEPA to essentially exclude or pick winners or to essentially shape a technology industrial policy is going to stretch that statute even more. And will be interesting, but I think it's going to happen. And the question for us is what will the courts do with it? Will they rethink these delegations? Will, as Mark mentioned, Congress try to come up with a way to provide some procedural checks on these sorts of delegations? Just two other quick examples of this same phenomenon, which is there a more obscure area of law than export controls that's controlled by the Commerce Department, and I know with the advice of the State Department, but suddenly it's a hot area where the Commerce Department in the last administration invoked its power to invoke export controls on the basis of human rights concerns, which it had never really done before, based on a very vague delegation. The export control laws itself were kind of questionable, but Congress finally approved them in 2018. But they're pretty broad, and the Commerce Department has enormous discretion who's going to be deemed a threat, when, how, who gets cut off, and for what reason. And the only criteria appears to be foreign policy interests of the United States, which is enormously discretionary. And given the scale of the U.S. relationship with China, will we see litigation finally to challenge the discretion of Commerce asserts over its export control policy? And then on a smaller scale, and again, this is outside the State Department's purview, but Section 232 of the U.S. Trade Act, which essentially allows tariffs on the grounds of, again, national security, another one of those delegations Mark was discussing, essentially, tariffs that national security, any imports that threaten national security, again, how do you, will a court ever question that? Now, I would just suggest courts have already started pushing back, even in the Trump administration. So unbelievably, the attempt to ban both TikTok and WeChat ran into judicial blocks. And it's hard. And now for complicated reasons that weren't directly related to the question of the president's power under IEPA. But one thing we might see is judicial questioning of these broad delegations to the president under these various economic statutes that delegate national security, or we might see Congress try to claw it back. There's a long academia is littered with articles saying Congress should do more to cut back on the president's power in foreign affairs. We could do this for 60, 70 years, and so far the direction, apologies to Gene on this one, the direction's all one way on this one, in terms of studying Congress's power. But it's certainly something that could happen, and I think that's I think something I really think will be driving our policy and driving our foreign relations law to support those policies. So with that, I'll cut myself off and listen to everyone else.
Great, thank you. So we have a few minutes before we turn things over to Mark and Rich for concluding remarks, if any. Maybe I'll just offer one question to Gene. So I love the article that this brief presentation is based on. I wonder, when I hear the argument about rejoining treaties, whether it might not have the unintended consequence of making withdrawals more likely by lowering the stakes of withdrawal. That is, if I'm a president and I know that a successor could easily reverse course, wouldn't it be easier for me to withdraw on the view that any long-term repercussions are perhaps easier to reverse?
I think that's theoretically possible, but it seems to me to be likely to be a marginal consideration at the end of the day. If a president wants to take the United States out of an international agreement, they want the United States out of that international agreement, right? And that seems to be the dominant force. Let me just cycle to Julian's apology to me and to bring in Mark's comment about Chadha, just to say that one of the challenges of so many of these delegations happen pre-Chadha, right? Yeah, and they're still there. And then the challenge of redoing it becomes very hard. I've started to wonder whether you might, have laws that implement, say, budgets on you get 20 emergencies and then you're done in every 4 years. Or, there's sort of additional possible creative ways to think about procedural checks that are not all done, but it certainly is. I agree with you that the trend has been towards more presidential power. I don't argue with that. I just ask the question of, is that what we want in a world where we can get such wide divergence in presidents?
Any other comments, Professor Keitner or Ku, in response?
I just suppose maybe that, really thinking a lot about, and will be long after this call, Julian's point about individuals and institutions, which I'm sure in various guises, all of us have been, pondering over the last few years, especially. And one thing would be to say, with respect to this executive branch assertions of authority point, certainly we see dramatic differences in what President Trump and President Biden seek to use that authority to do for the most part. And I suppose just a very important asterisk being that we did see strikes on Syrian territory under largely Article 2 authorities not too long before this panel was reported. But the dynamics of executive branch lawyers seeking to protect and expand executive branch prerogatives is something that I think is fairly continuous between administrations. And what I heard Mark saying is that maybe now, whatever the historical acquiescence has been, we maybe have some folks in Congress who are interested in pushing back a little bit more than maybe their predecessors have. And so it will be interesting to see again how those sort of institutional turf battles, not to characterize them as too adversarial necessarily, but how they play themselves out, particularly because, as Julian mentioned, this is not something that courts have indicated that they're prepared to wade into. And so we really are in this area of kind of informal kind of pas de deux between two of the branches. And so I'm not surprised that we will see assertions of authority, from executives with very different policy agendas. And then the interesting thing that will be, to what extent there's a new kind of mutual understanding about where, if any, the limits lie.
Okay, I want to give Julian another opportunity to comment if you'd like. But.
Can I? Yeah. I mean, I think actually there's interesting window in our time. But all the key acts I just mentioned, a lot of them, well, not all of them, but a couple of them were 1970s era, post-Watergate, pre-Reagan, a window of time when I wonder, there was a lot of reforms. There's almost like an article that needs to be written on this subject, which I haven't written yet or maybe never, but that there's this interesting window of time where the Foreign Sovereign Immunities Act, IEPA, and export control reform, and a bunch of really large, and like you said, Gene, they were all under the impression that they could impose procedural checks before Chadha came out in 1982. And so there's kind of a window of time. I wonder, another sort of interesting phenomenon is whether we're in a window of time where we have maybe an administration that's a little less aggressively protective of its power and more willing to give back a little bit and try to sort of smooth out variations of administration. That's something to think about going forward. But it will require the administration to make a choice that goes against its normal posture, like as Shemin said, which is, when in doubt, I work for the executive branch, we want more, right? And so that's, and I do feel like the Congress is kind of outgunned on this one in those typical debates.
Okay, great. I'd like to give Mr. Visek and Mr. Ayoze the last word. Mr. Visek, any concluding thoughts from your end?
Well, I just want to respond to what I thought were really interesting comments, particularly on the congressional relations side. I think one thing this administration has made pretty clear is that we want to have better relations with Congress and more cooperative. I think people tend to look at it as a zero-sum game. What's the executive branch's prerogative is not Congress's, and what's Congress's is not the executive branch's. I think it has to be more of a partnership. I'm reminded of that sort of old political science iron triangle where we had these mutually supportive relationships. I was not only alive, but I was heavily involved in that 19-year-old authorization bill that Mark alluded to. And it was a real lesson for me because I remember walking out a couple of years prior to that from a House markup, and one of Mark's predecessors turned to me in the hall and said, "Well, we've made sure that bill will never go anywhere." And I was like, "But there are important authorities in there," And so I think we need to look at the legislative process afresh and try to see how we can just improve government overall, which is, however naive that might sound. In terms of the institutions, whether the institutions or the people, I think one of the great things about the State Department and particularly about L is we have great retention. We have a lot of people who stay with L over the course of their careers, rotate, do different things, and it creates a real sort of strong fabric, if you will, for the ethos of making sure we provide good legal advice and we speak truth to power, and we give our best efforts as lawyers. I am reminded, however, whenever anybody says anything about how important the individuals are, Charles de Gaulle had that great quote that the graveyards are filled with indispensable men. So I think it really are the institutions, albeit the people have to nurture those institutions and the courts have to protect those institutions. And I could go on so many other things that were said because it was all fascinating. I will say very quickly as a wrap up to Professor Galbraith's questions, we are very early in the administration, so we haven't really gotten into the treaty review process yet in earnest. In fact, we still only have one confirmed political appointee in the State Department, and that's, of course, Secretary of State Tony Blinken. So hopefully we'll get more and we can get moving on these other things. And with that, I'll turn it over to Mark.
Okay, I'll respond very quickly in the interest of time. I think all really great comments that could merit a whole panel on their own. I think first to Julian's point on will Congress Congress has ceded authority for so long, and what will it do? I think it's a political reality that Congress steps up to assert itself when it has a real policy problem with what's happening, and that members are less likely to assert sort of institutional interests when they're fine with what the policy that's happening. I think that's something that was called into question over the last few years. I think with respect to open skies, Congress did put something on the table. They put a limit of 120 days advance notification to Congress for withdrawal, and I think you can. I don't think it's hard to see legal arguments why something that impacts a number of legislative authorities, Congress might have a legitimate interest in requiring some notification so that it can respond with appropriate legislation. Of course, the executive branch brushed that notification aside as an unreasonable infringement on the president's Article 2 authorities. Congress also didn't put its strongest foot forward, right? Congress didn't control funding or use our strongest legislative powers. So I think it remains to be seen sort of how Congress would continue to react if it felt like a policy wasn't developing in its space. I think, again, with thinking of policies, sort of first, as Shemin mentioned, I think a private right of action to respond to cyber attacks is something that might make sort of like intuitive sense to some members without really thinking of what have been the implications when we have created exceptions to sovereign immunity, and does that actually serve the implications that we want? That has thrown roadblocks up in the face of other international engagement that Congress has wanted the administration to be able to engage in the past. And so I think members connecting those dots is something that that is a challenge for Congress going forward. But I think in the end, to Rich's point, it's certainly should not be seen as a zero-sum game. And I think that's one of the things that I hope will be realized going forward, that even in something like treaty power, to the extent that you can get an implementing legislative framework in place in advance, that's going to be really mutually beneficial. And so having that regular engagement to figure out how to not see the relationship as adversarial, but to see the relationship as creating mutual opportunities is my real hope for the future.
Thank you so much. I just want to conclude by saying thank you to all the panelists. I've really appreciated your time. I know that you're all very busy, but I'm sure that the listeners have really appreciated hearing from you as well. I want to conclude with just two logistical points. One is that questions and Q&A session is available immediately after this recording. And second is that we're doing this recording on March 5th. So if anything happens between now and the time that it's streamed to make the comments seem off the mark, that's why. But anyway, thank you so much. And we look forward to hearing questions from the audience.